Welcome to the Biker Rebellion. I'm your host, Ginger, here with founding member of the Biker Lawyers, Pete Leahy. Once a month, we take a look through the comments section and see what questions our viewers have, then answer them. Now, a quick disclaimer. We're not handing you legal advice here. Everyone's situation is different. That's why we recommend talking to a lawyer about whatever you may be going through. That said, there is information worth stating, so let's get started with question 1. An Allstate-insured driver hit my car, admitted fault, and was ticketed. Even so, Allstate is refusing to pay and is stonewalling me. What should I do?
That's the classic case where you're going to need a lawyer, and especially if the other drivers admitted fault, they got ticketed, and the insurance company still won't pay, then you definitely need a lawyer at that point.
Fairly simple answer there. It's just call an attorney, talk to them. They'll be able to sort out what's happening with the insurance company. There's a lot of different steps. There's a lot of variables, but at the end of the day, it all begins with a phone call to an attorney.
The only other option that I can see is sue them by yourself, but that's typically not a very good option.
Yeah, that seems like it'd be a little bit rougher to try to navigate those waters when you don't have experience in them. I mean, these are waters that are not prepared for anyone without a Juris Doctorate to navigate.
It's hard enough dealing with an insurance company as an injured person when you're just trying to talk to them about your medical bills, but to get into an actual lawsuit with them, lawyers know the rules. Other people don't have any cause to know the rules, and you're dealing at a tremendous disadvantage. So going into a lawsuit without a lawyer would be nuts.
And I mean, I think it's worth clarifying. Not every lawyer handles these types of lawsuits, and there are people that, hold themselves out to be general practitioners. Is that who you would go to with a case like this?
No, I mean, you want to be sure that the lawyer you select is experienced in these things. I mean, there are all different kinds of lawyers. There are probate lawyers, there are business transaction lawyers. You don't want a probate lawyer handling your personal injury case.
Makes sense. All right, we'll move right along here to the second question. Is it true that my insurance company can hire a lawyer for me to fight someone else's insurance company? If so, should I trust them to handle it?
If you're the injured person, no, your insurance company isn't going to hire a lawyer for you. That's up to you. The only time an insurance company hires a lawyer for somebody that's involved in some kind of vehicle collision is when you're the one getting sued. So if you're the one that's hurt and you're seeking a recovery from somebody else, you don't want your insurance company making that selection, because if you ask their input, you're probably going to end up with somebody who typically defends cases for insurance companies. And maybe I'm biased. Well, definitely I'm biased.
Just a little.
But lawyers that work for insurance companies have a different viewpoint than those of us who work exclusively for people who get injured.
That makes sense. All right, question number 3. What is bad faith, and how do I know if my insurance company is guilty of it?
Bad faith is an extremely rare case that comes up when an insurance company does something with absolutely no reasonable cause or excuse. And it sounds, when I say it like that, it sounds like an easier threshold to meet, but it's really not. So the average person would look at things that an insurance company is doing in the course of a lawsuit and say, that's bad faith. But it really takes pretty outrageous conduct on the part of an insurance company to be bad faith. And the situation where it most recently comes up, for example, in a case where a car has hit a motorcycle.
Sure.
Let's say the dude driving the car had a $20,000 liability policy.
So state minimums.
State minimum.
For Iowa, at least.
Right. The guy on the motorcycle has $100,000 of medical bills,
Okay.
Not to mention a bunch of loss of income and pain and disability and all that. So clearly this is a case where the liability insurance company with $20,000 should pay up, and they should pay up quickly. If that company refused to pay, despite clear liability, despite damages that are obviously way beyond the limits of that $20,000 insurance policy, then the person with the $20,000 insurance policy would potentially have a case of bad faith against their own insurance company for failing to pay that $20,000 and get them off the hook.
Gotcha. So when your insurance company fails to act correctly to protect your interests, that's where you start to get towards bad faith. And in this particular example, we're looking at, an insurance company that has a clear reason to settle and be done at policy limits, and they're just not going to do it.
That's correct. And again, it's a situation where let's just stay with the $20,000 liability in a case that's obviously way beyond that in money, and a clear liability case. If you're the guy with the $20,000 insurance policy, you need to go get your own lawyer. Don't rely on the insurance company lawyer, because the insurance company lawyer to an extent is working for the interests of the motorist that caused the crash. But if you need advice on what to do when your own insurance company won't pay the claim that you're liable for, then it's time for you to contact your own lawyer, and they can then put some pressure on the insurance lawyer and the insurance company to pay up those limits.
Makes sense. All right, moving on to question 4. Can the insurance company refuse to pay my medical bills if the vehicle was not damaged? My vehicle was not damaged.
First, let me say that medical payments on an automobile, those are going to come into play if you're in a crash. And really where I see this most commonly is in an uninsured motorist situation. Let's say you have a situation where somebody crosses the center line, you go off the road, roll in the ditch,
Sure.
the guy takes off.
Right.
There's no contact with your vehicle.
Gotcha.
You've got no information on who the other person is. In Iowa, if there's no contact between the two vehicles, then you're not going to have a successful uninsured motorist claim. There either has to be contact, or you have to be able to identify who that person was that caused you to go off the road.
So let's say, John Doe runs me off the road. I'm on my Harley and runs me off the road, no contact. But they come back and they apologize, and they're like, "Oh, I'm so sorry. It was clearly on me. I didn't see you there. Are you okay? You've got medical damages. Your vehicle, though, for whatever reason, let's say it doesn't sustain enough damage that it's noteworthy. Like maybe a couple dings and scratches, but nothing that really translates to high vehicle damage or totaling the motorcycle, right? So in that scenario where you know who the other party is there a lawsuit?
Yes.
Okay.
In that situation, your claim is against the guy who ran you off the road, because now you know who he is, so your claim is against him, and how much damage there is to your motorcycle is completely irrelevant. Maybe you came off your motorcycle and went tumbling down a hill and got all busted up, and your motorcycle really isn't damaged. Doesn't matter. You still have a claim for your physical damages in that situation.
Gotcha. Let's move on to question 5. My doctor says I need surgery, but my insurance won't approve it. What do I do?
Call a lawyer.
Some of these are that simple, right?
I mean, we see this happen. And again, you could try to tackle it yourself and go into contacting the insurance company and trying to dispute their denial and that type of thing. But ultimately, if you're in that situation where your health insurance company won't pay your medical bills, then it's time to call a lawyer, because the lawyer is going to be able to put the pressure on them to pay the bills.
And it's probably worth noting these insurance companies are trying to retain as much of their own money as possible, because that's part of how they maintain their funds. And so by not paying bills and forcing you to go through this system, jump all these hoops, get through all the obstacles, they're making money on every day that you don't make them pay. Hence, lawyer.
Well, look, the bottom line is, if you've been hurt in a crash,
Right.
the person who caused the crash, their insurance company won't pay until the end.
Right.
So now it's either that your health insurance company pays the bills, or you somehow come up with the money to pay them yourself, which most people can't.
Right.
And that's where health insurance companies may have some incentive to deny the bills or deny the medical claims, but under the law, they are required to pay that if the responsible person won't. I mean, you're going to have to pay the health insurance company back when you recover money at the end of the case, but the health insurance company is obligated, while the case is still going on, to pay those medical bills.
So your health insurance company in this situation gets a thing called a lien. Is that correct?
That's absolutely right. It's called a subrogation lien. So let's say that your insurance company pays out $10,000 in medical bills on a case where somebody else hit you and is responsible. Theoretically, at the end of the case, you're going to recover for that $10,000 of medical bills along with other damages, but you got to pay your health insurance company back for the money it paid, because that was the responsibility of the other driver.
That makes sense. Question 6. I got hurt as a passenger in a motorcycle accident. Can I file a claim, and whose insurance is liable?
Yes, you absolutely can. And whose insurance is liable depends on who's at fault for the crash, and it might be a complicated answer to that. It might be partially the other person, partially the driver of the vehicle you were in or on, but the bottom line is, when you're a passenger, you've got 0% of fault. So between the other driver and the person you were riding with, those two are going to have 100% of the fault between them. It might be 100 on one, 0 on the other, or any variation in between, but it's you look at the fault of the two drivers.
And let's say, the person who's driving the car you're a passenger in, it's your buddy, it's your friend, but they are definitely the one that's at fault. Like they made a bad turn, hit somebody, you're injured. When you're suing to recover, are you touching their personal finances?
Probably not. I mean, you said it's your friend, so I'm going to guess that whatever your injuries are, you're probably not going to try to go after more than the insurance policy that they have. I mean, there's nothing legally that says you can't, but let's say your buddy has a $100,000 insurance policy and you've got a $500,000 in damages. You could go after your buddy for the difference between the insurance policy and your actual damages. It's just, it starts getting down to a personal and a practical matter that needs to be solved at that point.
Right. And we've addressed that in past podcasts already, like when you can go after those assets and whether it's worthwhile. And the reason I bring up the friend scenario is because we've seen those questions from some of the viewers now where, they don't know if it's okay to sue their friend. They don't understand what you're really doing is suing the insurance company for the policy limits, and everything after that's between you and the friend to a degree.
Right. So long as you're just going after your buddy's insurance policy, there shouldn't be any problem between the two of you. If you start going after your buddy's personal assets, that person's probably not your buddy anymore.
Right. You go after the house, different scenario. Okay. Moving on, question number 7 here. What should I know about insurance settlement tactics? I think I can handle this on my own, was a comment from a viewer.
Sometimes people can handle it on their own, but I'm going to say in over 90% of the cases, it's not a very good idea. Sometimes I get calls from people and they'll tell me, here's what happened, here are my medical bills, here's what happened with my job. The insurance company has offered this much. What should I do? And if the insurance company is being reasonably fair and in the game, I'll tell them, you might want to tell them they got to pay X dollars or you're going to hire a lawyer. But again, in over 90% of the cases, if you're dealing with an insurance company, you're dealing with somebody who's a pro, who does it all the time, and it's not a fair match. So most of the time, unless the insurance company pays up a fair amount right away, you're going to be better off hiring a lawyer and being sure that you've made the recovery you ought to.
Essentially, to give a metaphor here, the insurance company is playing chess and you're playing checkers a lot of the time.
That's probably a good way to put it.
And it's just different rules of engagement, and you don't fully understand where they're coming from or how they got to those numbers. But hiring somebody who is a personal injury attorney, they know how those numbers were reached to a degree.
Yeah. Again, it's a question of balancing the playing field, because when somebody who's not used to dealing with injury cases is dealing with an insurance professional, that person's at a huge disadvantage. The only way to balance the playing field is to hire a lawyer to come in and help you out.
Makes sense. Question number 8. My family keeps asking me about my case on Facebook or other social media. What should I say?
Stop it. Pick up the phone if you want to know how I'm doing. Don't do this on social media. See, the thing is, any conversations you have on social media, if you get involved in a lawsuit, the other lawyer is going to ask for relevant things from social media, and all of a sudden every discussion you've had with family and friends, which is a super bad idea, any discussion you've had on social media is going to be discovered by the other lawyer. They're going to get a hold of the actual comments that were made, and it could turn out to be very damaging. So yeah, keep any discussions like that off of social media. If you need to talk with your mom and dad about how you're doing, have that conversation on the phone or in person.
The internet is written in ink. You can't erase it. I know people think you can, but you can't. There's always a record, and there's a record if you erase it of you erasing it. Those data logs exist, so be aware that if you are putting something on the internet, it's written in ink, it's going to be there, or at least a trail of it will be there for other people to see.
Yeah, you might think you've deleted it from your Facebook account, and sure, sort of you have, because the public can't see it anymore. But again, when that lawyer asks for all the data, they're going to find it.
They're at least going to find a record of you deleting something, and they're going to have questions about whether or not you deleted something of relevance to the case.
Look, posting anything, I mean literally anything, on social media about your crash case, it's an enormous mistake. You just don't do it.
Now, of relevance here, let's say, you're a year out of the crash, but the case is still going on, and you get on social media and you post a picture of yourself in a swimsuit in the Bahamas or something. What about that?
It's going to be discoverable. I mean, your condition and how the crash has affected your life are very relevant in your case. So, I mean, nobody's saying that you shouldn't take that vacation and you shouldn't go swimming. But as a general rule, it's just a bad idea to put pictures out there for the public to see of you doing all the different things that people normally think of uninjured people do.
Right.
But I mean, again, there's nothing wrong. And I tell people this all the time. If you can get on a plane and go to the Bahamas and get in the water and go swimming, by all means, do it.
Sure.
And if anybody ever asks you about it, you admit it. But let's not put pictures of showing it on Facebook.
And perhaps one of the reasons there is context. You went and maybe you were in pain, but you still muscled through and you had your vacation and you tried to, have a good time with your family. But a picture takes a lot of that context out when all they see is you with a smile on your face in a swimsuit. They don't see the pain that you're going through. And now it's an issue.
Yeah, if there's a picture on social media, like you say, you're in a swimsuit, you're in the water with a smile and a red drink with an umbrella in your hand. Right. Doesn't matter what you say about the pain you were having at the time, they're not going to believe it.
Right. So, to summarize very quickly, don't post about your case on social media.
Can't say it any better.
Fair enough. Question 9. I've heard something about a permanent impairment rating. What's that all about?
So, impairment ratings are a real common thing in a workers' compensation case, but they're also relevant in a personal injury case like a car crash, motorcycle crash type case. Basically, a permanent impairment rating is a measurement taken by a doctor trained in doing impairment ratings that assesses how much of your full body that you've lost as a result of a crash. And I mean, like when you lose an arm, that's easy to see. But for example, when somebody has a back surgery and they've got permanent physical limitations on what they can do, they still look like they're 100%, but it takes a doctor that's trained in doing impairment ratings to go through and say, no, this is not a 100% person anymore. It might be a 95% person or 92% or whatever, but permanent impairment is an important concept in injury cases because that's how you show a jury that this guy who looks normal isn't.
Question 10. I was injured in a car crash, but I wasn't wearing a seatbelt. Do I still have a case?
Yeah, but so in Iowa, you can be assigned up to 25% fault for failure to wear a seatbelt. The lack of wearing a seatbelt is relevant in Iowa, and if the defense can show that your injuries were worse because you weren't wearing the seatbelt, then a jury can assign up to 25% fault to you for failure to wear a seatbelt.
What does that percentage mean if you still win the case?
So let's say that you get assigned the 25% fault.
Okay.
Which means that the other driver is assigned 75% fault.
Mm-hmm.
Let's say that the jury verdict is $100,000.
Okay.
You're not getting the $100,000. It's going to be reduced by your fault, your 25%. So $25,000 comes off of your verdict for failure to wear a seatbelt in that scenario.
And I think this is just worth clarifying. On a motorcycle, there are no seatbelts, and it is not against the law.
Right, but then you get into the whole issue of, was he wearing a helmet or not?
Gotcha. And how often do you find that to be of relevance?
Well, never. I mean, in Iowa, there is no law that says you have to wear a helmet. It may well be different in other states. I know lots of states, more than don't, have helmet laws, and some may have provisions that say you can be assigned fault for not wearing a helmet. But in Iowa, there's no helmet law, and you cannot be assigned any fault for failure to wear a helmet. And this is a really important point because literally every motorcycle case I have ever handled where my client was not wearing a helmet, the insurance lawyer wanted to tell a jury about it, but it is completely irrelevant and should never be presented in front of a jury.
Alrighty, that's all the time we have for this week. If you want to have your questions answered in a future video, comment below. And while you're down there, click click that subscribe button to make sure you don't miss the answer. Brought to you by the Biker Lawyers. Injured? Ride with us.